Hey everyone, Judicial Watch President Tom Fitton here with our weekly update on social media. Thank you as always for joining us this week. A lot going on. Judicial Watch, frankly, has been a force of nature this week in terms of pursuing and trying to expose government corruption. New lawsuits on the Biden attack on Trump. New lawsuits on critical race theory and the assault on our military. And a major new lawsuit by Judicial Watch over YouTube censorship of Judicial Watch. So a lot going on. First up, though, is the new Freedom of Information Act lawsuits that Judicial Watch filed on the Biden raid on Trump's home. The unprecedented, reckless Biden raid on Trump's home that was, as I say, conceived in sin. In the sense, and I'm going to repeat why it was conceived in sin, because the Justice Department had no good faith basis to target Trump for records they had no business having, because Judicial Watch had uncovered, or we had tried to pursue 10 years ago plus, records that Bill Clinton had, tape recordings he had of meetings or phone calls he was having with foreign leaders, phone calls he was having with members of Congress, all of which, under the Justice Department's theory, now would have been covered under the Presidential Records Act. So when we sued, advocating just that point of view, the Justice Department told us no. If the president had those records after he left the presidency, they were presumptively personal. And the court ruled to that effect as well, suggesting that the archives had no business asking or trying to get any records that a president had delineated or kept on his own after the presidency. So there was no authority to even demand the records, according to this court analysis, not only the Clinton records case, but looking at major appellate and Supreme Court decisions that guided the decision-making there. And so when the Justice Department and the archives started harassing Trump over these records and started, well, obviously they raided his home looking for so-called classified information. There was no basis for that because the information necessarily was personal, necessarily was unclassified. And Judicial Watch has been in the forefront of highlighting that. You know, we're sensitive about that issue. You know why? Because we lost. We made the arguments the Justice Department is making today, and they told us we were wrong. And all of a sudden they changed their minds, did a 180. Why? Because it's Trump. So it's that type of lawlessness and double standards. Bill Clinton's protected while Trump is targeted. Just remember that. Bill Clinton has been protected when it comes to presidential records while Trump has been targeted. And there's been other news about Barack Obama and records that he may or may not have had that were not in the custody and control of the presidential archives, the National Archives. Evidently, he had records in a warehouse. The communications I saw indicate. Now, of course, the National Archives is coming out with statements saying, oh no, they were always in our custody and control. Well, the records don't suggest that or seem to contradict that. So there's a lot of debate about why it is they treat Trump one way while treating Bill Clinton in the least. We know for sure another way, and we're still looking at how they were treating Barack Obama. So what Judicial Watch has been doing, obviously, is educating the American people about this issue. We began doing it in February when this issue first popped up. The media started going after us, trying to, quote, fact check our analysis, which was hilarious because Judicial Watch is the nation's leading expert on federal records issues. We've been litigating those issues for nearly 30 years. And so then the raid happens, and they really go crazy because the media starts putting out news stories suggesting that I had been advising Trump one way or another on this records issue. And as I told you last week, I'm not confirming or denying who I'm talking to or whether or not I've been providing advice to President Trump or telling him what I thought. It's none of their business, and frankly, it's none of your business, with all due respect. So the media's gone crazy. But the reality, and of course, what the response is to focus on how I look rather than the arguments I'm making as it relates to the prior policy precedent and law related to the handling of records. And Judicial Watch, once the raid happened, we knew it was corrupt because, again, it was a complete 180 from prior Justice Department positions on the status of records in the custody of a former president. And we sought more information about the raid. We took the lead and successfully unsealed the affidavit, which showed that the raid was based on weak tea and based on, it looks like, a dishonest presentation of the law to the magistrate judge who signed off on it. And then shortly after the raid, after we successfully obtained more information or forced the release of information about the raid, we sued the National Archives, which has been hiding records about issues tied to the raid. So isn't that rich? You've got the National Archives talking about how important it is the American people have access to records while hiding records in violation of the law from the American people. And in the meantime, you've got the Justice Department and the FBI also ignoring Freedom of Information Act requests from Judicial Watch. So what did we do? We just sued them again and again. So lawsuit number 2 and number 3 on this raid. We've got 3 federal lawsuits now, and the 2 most recent ones were against the Justice Department / FBI for records about the raid. Let me pull up the release here and I'll give you the specifics of what we were asking for. We asked for these records back in August, so they've had more than enough time to respond. You know, technically the government has, not technically, under law the government has 20 days to acknowledge or respond somehow to your FOIA request. And sometimes they can give themselves an extra 10 days administratively to respond, so more or less a month. And if they don't respond, you can sue. But we know the government's slow, and we don't sue, usually we don't sue immediately upon the 20 or 30-day deadline, because sometimes we might get records shortly thereafter, and no use wasting court resources if it's just going to be processed and, you know, just waiting a few days will get us the information. But we have significant experience in figuring out when we're being ignored and when only a lawsuit is going to get information, and that's the case here. That's why we sued the Justice Department and the FBI for really basic, simple sets of records. The first set was all records or meetings or phone calls between the FBI Director Wray, his Deputy Director, his Associate Deputy Director, and other folks pertaining to the search warrant. Also included are communications between the FBI and the Executive Office of the President. So they're hiding any records they have. They're refusing to tell us even whether they have records about communications between the FBI and the Executive Office of the President, the Biden White House, about this raid. And also we want records between the FBI and the Secret Service about this raid, because as you may recall, the Secret Service helped enable this attack on the President's civil liberties with this illicit raid. So the FBI is hiding all those records. And similarly, the Justice Department is also hiding records. We sought all records documenting the application, the authorization, and communications related to the execution of the search warrant at the residence of former President Trump. So we want records about the raid. What's so hard about giving us records about the raid? And in our experience, if they don't want to give basic information about something that is of significant public interest, that the Justice Department and Attorney General Garland has already admitted, something that's of significant public interest, never before in the history of the United States, as the Justice Department or any federal law enforcement authority raided the home of a former president. And certainly not a raid on the flimsy pretext of a document dispute. Who are they kidding? No wonder they don't want to give us any documents. So we've got the lawsuit against the National Archives, we have the lawsuit against the Justice Department, we have the lawsuit against the FBI to get records about this raid. And obviously, maybe it's not obvious if you don't know about Judicial Watch, but if you know about Judicial Watch, it is obvious. This is just the beginning. Because we have other FOIA requests you can be sure we'll be pursuing in court when the need arises. And so just so you have a brief update as to what's been going on with the document fight between the Justice Department and the Trump team. So, I highlighted this special master last week. He's a senior judge, which means he's not working full time. He works part time for the federal courts as he kind of goes into retirement. But it looks like he's been going a little too far or beyond what the Judge Cannon had authorized in setting up the special master process. He was speeding things up. He was also requiring President Trump to affirm certain information, potentially under oath, that the special master appointment order didn't really contemplate. And so the judge clipped his wings. Judge Cannon came in and said, no, A, they can get more time, and B, the president doesn't need to come in and go under oath about what the nature of these records are. That's just a step too far. This is a document dispute issue. But the judge evidently wanted to conduct some type of discovery or something of that nature, or put people under oath on the record. And it seemed to be a little bit aggressive in the sense that it wasn't required for him to do his job. And on top of that, it turns out, and this is the other news this week, is that the government kind of admitted to the Trump team, after being dishonest and withholding this information seemingly from the court, even though they likely knew better, that they didn't take, quote, 11,000 documents from the president's home, but it was actually 200,000 pages. So, when you're in a fight with the government, sometimes they argue with you about, well, this is a record, is this a document, how many pages are in the document? So, depending on what definition you're using, you could have one record that has 10 pages, or one document that has 10 pages. And so when people are saying there were 11,000 records or documents taken, unless someone says something otherwise, you're just assuming typically that it's pages. Turns out there were 200,000 pages. So which shows you just how broad and expansive and abusive the raid on Trump's home was. So you've got this still percolating along, and of course you've got the president being abused out of the New York Attorney General's office in New York with another civil lawsuit designed to destroy his company. You have another local left-wing attorney, the district attorney in this case, in Fulton County, Georgia, trying to target and jail folks who were concerned about the elections in Georgia and who were exercising their First Amendment rights. You have the continued abuse of the January 6th Rump Committee, run by the Pelosi gang. And of course you have the Justice Department, which is still harassing American citizens who had the temerity to dispute Biden's election by exercising their rights under the First Amendment and other amendments of the Constitution and federal and state law to raise questions about the election. So you've got this major suppressive effort by the Justice Department, by Congress, by state officials targeting Trump. And the icing on the cake, or maybe the worst aspect of this, is their raid on his home. And so the media probably wants to move on from this, but Judicial Watch isn't going to move on. We're going to try to figure out what went on with this wildly abusive raid on his home. And we're going to stand for the truth, and we're going to stand for the rule of law. Because as Trump has always, as observed many times before, they want to get to you through him. And so the abuses you're seeing of President Trump are abuses, frankly, that others have already been targeted with in these January 6th out-of-control investigations. So this is serious. This is not about Trump. It's about whether the civil rights of all Americans are going to be protected from politicized law enforcement entities at the federal, state, and local level. So this is a dramatic time for the American experiment. And you can bet Judicial Watch is going to stand on the side of the Constitution, stand on the side of the rule of law, and stand on the side of a Republican form of government that the left these days seemingly wants to overturn. Well, speaking of suppression, as I've often noted, we're in the middle of the Great Suppression. which is the suppression of speech by big tech, which is controlled by the left, in collusion with their leftist allies in the media, the so-called fact-check organizations, which are really just left-wing censorship groups, and most dangerously, the government. And the Biden administration has been public in its embrace and of the idea that citizens who say things they don't like should be censored by big tech. Not only on election issues, but on public health issues and debates about COVID and policies and such, and pretty much anything else that they think they don't want them talking about. And you see that even with the suppression of parents, for instance, who are speaking out against what schools are teaching their children. You have the Garland operation suggesting that they're terrorists for raising issues like that. So there's this great suppression targeting our First Amendment protected speech. And one of the victims is Judicial Watch. Another one of the victims is me, because I work at Judicial Watch, and I'm often online for Judicial Watch presenting information, like in videos like this one. And just before the 2020 election, YouTube deleted a video, a weekly update video excerpt that we had put out there about election integrity issues. And we subsequently found out they did it at the request of the California Secretary of State's office. So you know what we just did? We sued the California Secretary of State's office for their violation of our civil rights through that outrageous censorship. Here's the release. Judicial Watch sues California Secretary of State for causing YouTube to censor key election integrity video just before the 2020 election. We got these, we figured it out because our intrepid lawyers and investigators extracted documents from the Secretary of State's office documenting this massive program that was done in league with the then Biden campaign's PR operation to target American citizens who were saying, quote, the wrong thing on elections, leading to outrageous censorship. Talk about election interference. That's election interference. So we filed the lawsuit. When did we file it? I guess we filed it last week. So we announced it this week. And it's an historic lawsuit, let's be clear. Because here we have, we're suing a government entity directly over their collusion with big tech, specifically Google/YouTube. And I hope YouTube is paying attention to this video, because we got some questions for you as well, you can be sure. I'm going to read you a significant section of the lawsuit because I think it's important you know about the illicit activity that taxpayer-paid officials were taking to violate the civil rights of Judicial Watch. And as I've noted before, when our rights are violated, when we're censored, it means you're censored because you're being denied access to information you want to be able to see, right? And of course, Judicial Watch, you know, it's not just me. We've got dozens of people on staff. We've hundreds of thousands of supporters. So this is a mass attack on the civil liberties of Americans. This is the statement of facts. So just to be clear, we're suing the Office of Secretary of State. The Secretary of State in California is Shirley Weber, so we're suing her in official capacity. So we're not suing her personally, we're suing her as an official of the government. And there's an office in the Secretary of State, which is called, this is what I love, the Office of Election Cybersecurity. It looked to be more concerned about targeting First Amendment rights than protecting the security of elections, as I'll disclose here. And this is how we describe it. It is not the role of the state to police the opinion of citizens. Yet the Secretary of State's office did just that when she monitored Judicial Watch's YouTube channel, purportedly assessed the contents of a video we posted on the channel as being, quote, misleading, unquote, and caused the video to be removed from YouTube's video sharing and social media platform. Plaintiff has maintained a YouTube channel. Plaintiff is Judicial Watch. So when I say plaintiff, I'm referencing Judicial Watch. since May 16, 2006. That's a long time. How many years is that? Almost 20 years now, right? Among plaintiff's other social media presences, plaintiff's YouTube channel is an important means of communicating with its followers and supporters and disseminating information to the public in furtherance of the organization's public education mission. We've posted over 4,200 videos. I'm actually disappointed. I think we should have more videos than that. And as of the date of this complaint, we've garnered nearly 94 million views, and our channel has more than 502,000 subscribers. So we got to get those views up. So if you're watching, help us get it up to 100 million so when we can update the lawsuit and add 100 million. On September 22nd, 2020, we posted on our YouTube channel a video entitled Election Integrity Crisis, Dirty Voter Rolls, Ballot Harvesting, and Mail-in Voting Risk! Exclamation point. It was a great video and I encourage you to watch it. You won't be able to watch it on YouTube though. The 26-minute video featured Judicial Watch President Tom Fitton discussing vote-by-mail processes, changes to states' election procedures, ballot collection, sometimes referenced to as ballot harvesting, and states' failures to clean up their voter rolls, among other topics. Mr. Fitton's comments were informed by successful lawsuits brought by Judicial Watch against Los Angeles County and the defendant, the Secretary of State's Office of California, in 2017 to compel the county and state to comply with the National Voter Registration Act's voter list maintenance requirements. And also we had another lawsuit against Governor Gavin Newsom, and maybe we should call him Newsman. That's probably a better name, right? And the defendant, again, the Secretary of State's office, in 2020, challenging the governor's attempt to unilaterally change the state's 2020 election procedures to an all vote-by-mail system. The former resulted in a consent decree that compelled defendant in Los Angeles County to implement several new practices and procedures to clean up state and county voter registration rolls. The latter, the lawsuit against Newsom, compelled the state of California to comply with the Elections Clause, Article 1, Section 4, and the Electors Clause, Article 2, Section 1 of the Constitution, to change its 2020 voting procedures to an all vote-by-mail system. And in that case, we got a big fee award, so they had to pay some of our legal fees. And that California case, as I recall, against Newsom, was I think they were going to mail a ballot to everybody, whether they were active or inactive registrants. And we sued, and they backed off and said, okay, we'll only mail to people who are actually living here, which is essentially what an active voter is versus an inactive voter. The views that Mr. Fitton shared in the September 22nd, 2020 video were supported not just by Judicial Watch's own substantial experience advancing election integrity and successful litigation against the defendant, but also by nonpartisan and bipartisan studies and reports and numerous other sources. The comments were neither false nor misleading, nor was there any evidence that Mr. Fitton's comments, quote, may suppress voter participation or cause confusion and disruption of the orderly and secure administration of elections, unquote. So what I was doing, if I recall from that video, I don't think I've looked at it recently, is I was probably talking about the case where Los Angeles County was committing to clean up to 1.6 million rolls from their names from their voting rolls, which strongly suggested the voting rolls were dirty. General concerns about vote by mail in terms of the security of that and the potential for fraud that is almost impossible to detect because people aren't voting in person. You know, the typical discussions around election controversies and election integrity measures. But we were told on September 25th, 2020, that YouTube removed Judicial Watch's video, and the video hasn't been available since that date. So we subsequently learned through a California Public Records Act request that the Secretary of State's office had purposely assessed plaintiff's video to be misleading and caused the video to be removed from YouTube's sharing platform. Specifically, on or about September 22nd, the Secretary of State's office listed our video on its misinformation tracking sheet, or misinformation tracker. So under the column linked, entitled screenshot/text/linked, they attached a link to our video, and it looks like they're quoting our video. The states are taking reasonable steps to clean up the rolls. That led in part to a settlement with Los Angeles County, as I already told you. Then I talk about how in Michigan, the court changed the rules to allow them to count ballots 14 days after the election, and mandating ballot harvesting. And what is ballot harvesting? It basically means anybody can take anyone's ballot and bring it to the polling place. Again, more opportunity. And I guess that gets cut off. Under the column entitled Misinformation, this is what they called misinformation. Ballot collection harvesting voting rolls. Head of conservative group Judicial Watch hosts video alleging Democrats benefit from incorrect voter rolls and ballot collection. Had 2,398 views as of 4/07/9/22. So here we have a government official tracking what Judicial Watch is saying, tracking what I'm saying. Maybe I should have sued too. Am I a defendant here? I should be. They're figuring out how many people are watching the video, and they're concerned that I'm criticizing, it looks like, Democrats. And I don't know if I criticized Democrats in the video. I probably didn't. Under the column entitled Indicator, OEC wrote ballot collection. Under the column entitled Social Media Action Taken, OEC wrote video was removed from YouTube. So OEC is the Office, again, of Election Cybersecurity in the California Secretary of State's office. So there you have the confirmation that our video was removed as it relates to OEC's tracking for, it looks like, partisan purposes, this video. Again, under the column entitled Result, OEC wrote removed. Now then we got emails showing how it worked. So on September 24th, the Secretary of State's social media coordinator emailed an email address at Google and copied 4 YouTube employees with the subject line, "Report video, election integrity crisis." Again, the title of our video. In the email, they wrote, "Hi, YouTube reporting team. I'm reporting the following video because it misleads community members about elections or other civic processes and misrepresents the safety and security of mail-in ballots. Thank you for your time and attention on this matter. All the best, Aquila." That's the name of the government official who got us censored, in part. And then they responded, like almost immediately, it looks like, the next day. "Hi, Aquila. Thanks for reaching out. We will look into this and get back to you as soon as we can." Later that same day, we noticed the video was taken down. And then 2 days later, YouTube confirmed to the government that our video had been removed. "Hi, Aquila. Circling back on this. Thank you for raising this concern to our attention. This has been removed from the platform for violating our policies. Please do not hesitate to reach out if there are any other questions or concerns you have." On information and belief, that government agency did not make a finding that our video may suppress voter participation or cause confusion and disruption of the orderly and secure administration of elections, which is what the California law that allows this agency to operate, this specific sub-agency to operate, directs them to be concerned about. Nor would any such finding have been warranted or otherwise supported by evidence. So they really didn't make any finding, and obviously we weren't doing anything wrong, so there was no negative finding to make. That's what that paragraph means. This is very interesting. Notably, the censored video is a portion of a longer video posted by Judicial Watch on our YouTube channel that addressed issues in addition to election integrity. The longer video, which this government Secretary of State's office in California did not bring to YouTube's attention, remains available on the channel. So draw your own conclusions from that. By assessing our video to be misleading and causing the video to be removed from YouTube, the government injured our public education mission. When plaintiff's video was removed, it had only 5,531 views. It had only 5,531 views. OEC's actions prevented us from reaching tens of thousands of viewers with our message. So we go on and talk about this, and we also highlighted in the lawsuit that we were concerned that they were monitoring our social media directly. And it looks like they were using a partisan public affairs and consulting firm called SKDK Knickerbocker. SKDK is kind of what it's known as. And during that time period, that firm regularly sent Dresser, Jones, and other officials, and Dresser and Jones are individuals in the California Secretary of State's office, misinformation daily briefings. Now, that firm specialized in working for Democratic Party politicians and employed notable figures like former Obama White House Communications Director Anita Dunn, who's now working in the Biden White House, and Hillary Rosen. In September 2020, the firm was advising the Biden campaign. So here you have California Secretary of State officials targeting and monitoring and spying on Judicial Watch, calling attention to YouTube to get our video taken down. And who are they working with to get all that done? Who are they relying on to do this social monitoring of not only Judicial Watch, but others? Other innocent Americans? The Biden campaign firm. So you've got a campaign colluding with a government official, it looks to me. And of course, YouTube is happily working with them to censor material in a way that it looks to me is designed to benefit the left. So we have alleged violations of the civil rights laws, 42 U.S.C. 1983, which is a core civil rights law, a violation of the First and 14th Amendment, and also a violation of the Free Speech Clause of the California Constitution. So this is a big lawsuit we filed, and I took the time to go through the specifics with you in a hopefully unconfusing way to highlight that we're not just making an outlandish allegation, oh, we got censored, the government must have been involved, let's sue someone. No, we got censored, and we tried to figure out what went on. We saw a news story, because there were news reports about this censorship campaign out of the California Secretary of State's office, so we asked questions about it. Lo and behold, we show up in these documents. Lo and behold, we find out our YouTube video was taken down just before the election. Remember, the election was in November 2020. Our video was taken down, what, 6 weeks beforehand, 7 weeks beforehand? You may recall there was a lot of debate about vote by mail and what it would happen. And we were participating in that debate as a leading group on elections. We're national election law experts. We know what we're talking about. We litigate the issue successfully and repeatedly. I testified to Congress in 2020, I think not once but twice. My colleagues another 4 or 5 times. And they're censoring us? So I don't know what's going to happen with the lawsuit. I hope we win, obviously. But now we get to pursue this issue, and the California Secretary of State's office in the lease is going to be held accountable. You can bet we're going to have questions for YouTube and Google. And obviously we're looking at what else is going on in this great suppression. I was just talking to a reporter today. Just the News had a big story about how the Department of Homeland Security was colluding with these private groups, again, to target specific Twitter and social media accounts who from these leftists thought were peddling, quote, misinformation. Now, misinformation is information they don't like, just to be clear. And I was number 5 on the list, on this hit list. There was another entity that was putting out more, another hit list just recently. I was number 3. So I'm actually getting better. The first one was I was number 5, now I'm number 3. Who knows, maybe I'll be number 1. I'm the number 1 target for the left on social media. The left is an enemy of the truth. They're an enemy of truth-telling. They are the enemy of critics of the state. They're an enemy of critics of efforts to undermine election integrity. The left is an enemy of the First Amendment, of free speech, your right to petition your government without retaliation. I mean, we sued this California Secretary of State's office, and they suppressed our speech in talking about the suit. So this is a major issue. It's broader than even California. As I said earlier, the Biden administration's into this major censorship, this great suppression, and we are investigating that, trying to figure out what's going on there. But again, Judicial Watch just doesn't talk. We act. And in this case, the action is a major civil rights lawsuit against California's Secretary of State over its effort successfully to cause YouTube to remove a video of Judicial Watches featuring me highlighting and educating Americans about election security issues. So we've got our republic under attack in so many ways, and one of the most significant attacks on our republic is this repackaged Marxism that is being pushed under the rubric of critical race theory or critical theory, whatever you want to call it. And it is the animating policy and agenda item for the Biden administration. It's infecting our schools. It is infecting our corporate culture. And obviously, the left-wing controlled entertainment culture is also pushing and promoting it. And it's the idea that America fundamentally is corrupt and racist, and has been and forever shall be unless the Marxists come in and overturn our systems of government, using race as a pretext to blow up everything we consider to be important about the American constitutional system. And of course, no attack on America would be complete without an effort to undermine our military by the left, of course. So critical race theory is, it looks to me, one of the number 1 agenda items for the Biden military leadership. They're forcing troops and officers to go through critical race theory training. Again, that attacks America and basically suggests that the military ought to be opposed to the American way. And specifically, also, they're targeting our rising leadership that's trained at our military academies, such as West Point, the Naval Academy, and also the Air Force Academy. Now, Judicial Watch already has lawsuits against West Point that has exposed the CRT anti-Americanism training for the rising officer corps there. And similarly, at the U.S. Naval Academy over in Annapolis, we just filed a lawsuit, I guess, about 6 weeks ago for records about any CRT trainings going on there. Now, we've also just begun working with a group of fine former members of the military who are concerned about this issue generally, and specifically concerned about what's going on at the United States Air Force Academy in Colorado Springs. We filed a lawsuit on behalf of this group. It's called Stand Together Against Racism and Radicalism in the Services, STARS, and we filed it against the United States Department of Defense for U.S. Air Force Academy records regarding, quote, systemic racism, as well as records of critical race theory trainings and policies at the Academy. Now, STARS had filed a series of FOIA requests that were pretty darn simple and should have been easily responded to. And it's pretty clear because these are military guys. So their first instinct, it looks to me, isn't necessarily to sue. They're thinking, well, maybe their former colleagues who are still in the military will understand they have a right to these documents and they'll just give them to them. No, that's not the way it works in today's military. If you want information, too often you have to sue. I jokingly say, you have to sue to get the time of day from the government. There was a memorandum issued outrageously in July of 2020 that stated in part, systemic racism exists in our society and our U.S. Air Force Academy community is not immune. The memo also stated there would be a, quote, an institutional assessment and review for biases within our policies, processes, practices, curriculums, and artifacts. And that will be used to make tangible, lasting changes and to inform our future actions. Now, we asked for records about that memo and what was done in response to it, or STARS did, and they got, as I always say, the proverbial hand to the face by the U.S. Air Force Academy. And they also want records about any CRT trainings that are taking place. So just so you know, so you may recall that when Trump figured out that all this CRT training was infecting the military, he took steps to pare it back and restrict it. And like memos like this were probably one of the bases for Trump saying no more of this anti-Americanism, critical race theory, which targets and divides our military based on race. So the Biden administration came in, and as I said, critical race theory is the number one an animating agenda item for Biden administration governance. So this is why we're committed, and we could probably have do nothing but FOIA lawsuits against this federal government on critical race theory alone. And so we're always pleased to see other groups who are interested in this issue as well. So it's good to kind of, join forces with STARS to figure out what went on. STARS is concerned about efforts to teach and implement aspects of CRT in U.S. military academies and throughout the U.S. Armed Forces. And it was founded by a group of distinguished retired military officers. Now have 2,932 members, including general officers, service academy graduates, retired and active duty officers, and enlisted, and of course, concerned citizens as well. And you can see what they're about at stars.us, stars.us. It's STARRS.us. So Lieutenant General Rod Bishop, who's retired, is a U.S. Air Force retired general, he said about this lawsuit, the superintendent's claim, the Air Force Academy superintendent's claim of systemic racism at the academy does not comport with our experience. So we filed a FOIA request to learn more from the assessment he demanded. This was not a complex request, as I said. The continuing refusal to respond to this request speaks volumes. And General Bishop is right. Our view is that when basic requests are ignored, especially about a controversial issue, it's because the government has something to hide. And as I say, we've got this rising leadership at the Air Force Academy who are so precious to the future of our national defense. And what are we doing? We're allowing them to be abused by the Biden military leadership, the military leadership of the U.S. Air Force Academy, who it looks to be force-feeding them repackaged Marxism that's designed to make them hate America rather than try to protect America. I mean, this is an awful situation we're in. It's a dangerous situation we're in. And Judicial Watch is, we're not going to slow down a bit on trying to figure out what's going on here. So we're honored to be able to work with the retired leadership of the military to hold accountable the active leadership of the military and protect those men and women in uniform who are there to defend the country. And the least we can do is not harass them and try to make them hate the country. And I guess if you're a Marxist communist who wants to blow up the United States, that's something you want to do. But if you want to preserve our republic, you want to protect our military from this politicization, the end point of which would be, I think, the end of the nation if the left gets their way. And with that, I encourage you to go online to Judicial Watch's website at judicialwatch.org and access all the information I'm talking about, the documents about government censorship in collusion with big tech, the documents about the Biden raid on Trump's home, the assault on the republic there, and of course the assault on our military through this critical race theory Marxism that's being used to try to brainwash our rising leadership in our national leadership academies for the military, whether it be West Point, the Air Force Academy, or the U.S. Naval Academy. This work is essential. I encourage you to educate yourself about what we found. I encourage you to support us so we can do even more of it. And I encourage you also to spread the word about what we're doing so even more Americans are aware of what their government is up to, both the good, the bad, and the ugly. And with that, I'll see you here next time on the Judicial Watch Weekly Update. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.